Custody. My child is 12. Now what? That is your topic for the day with attorney Dannielle Simms on my podcast. Welcome to the Lawyers and Mediators International Show and Podcast, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hey everyone, this is attorney Mac Pierre-Louis, lawyer, mediator, arbitrator, working for Florida and Texas. And with me is my colleague, Dannielle Simms. Welcome back, Dannielle.
Hi.
Dannielle, so we're here now to talk about child preferences. But before we do, I want to give you the opportunity to say a little bit about yourself, because it's been a few weeks since you've been out.
Well, happy holidays, everybody. And if I don't see y'all, happy New Year. Just a little bit about myself. I practice here in Harris County, Texas. I also practice out in Montgomery County, Texas, Brazoria County, Texas, Galveston County, Texas. I'm here in Texas, guys. I have been practicing family law for, good Lord, I don't want to age myself. It's been exclusively maybe about 10 years, been licensed about 12. And so I do a lot of CPS work, do a lot of family law work that includes divorces, custody cases. I actually do a lot of amicus work myself. I mediate a little bit, not as much as you are, but I mediate somewhat. And so, I'm here to meet all of your child custody, divorce needs, and CPS needs. So.
Awesome. Thank you so much. And thank you so much for the shout out about mediation, because that's always the thing I want to be pushing, so that if we can't help you in court, then we can also help you in the conference table as well.
Yes, I know you're a big trying to offer solutions, and that's great, because mediation is always the best way to craft your life. However, I'm a litigator through and through, so I like to do both. But if we can't solve it, I'll solve it.
Exactly. So when we get to the topic of litigation in terms of children who have reached 12 years old, let's talk about that topic today.
Sure.
Okay. So at what age can a child give their preference in Texas?
So it needs to be clear that a child's preference can always be considered no matter their age. However, it's codified that a child's preference shall be considered at the age of 12. Before the age of 12, it's may, meaning we might consider it. At the age of 12, it's we shall, meaning the judge shall talk to the child if there's a request for an interview. A child's preference shall be expressed to the court, meaning it has to happen, guys.
Exactly. And so that's the mechanics of it. But what about how it actually flows? Just real quick before we get into how much weight the judge will give the child's voice. Before we get there, how does it actually flow? In my experience, it's you file something to ask the court to speak to the judge, and then you have a hearing, and the judge will say yes or no, and then we'll get the kids scheduled in. Has that been your experience?
Yes. And so what you see a lot, and sometimes you'll see child preference being considered in divorce matters or in original custody suits. But what you see a lot is it happening in modifications, meaning, hey, we have a prior order and the child, this is how the order went, but my child is 12 now. It's not working anymore. He or she would prefer to either live with me or not visit so-and-so, or they want their visitation schedule to look different. So what you'll see is a lot of modifications that are initiated based solely on the preference of a child. And so that will be filed. It will be a statement within the pleading that says my child is 12, essentially my child is 12 now, they've expressed a preference. But mechanically, a lot of times what folks will do is do a child interview. And so what you do is file a motion for the judge to speak with the child. When the child is 12, it's a shall. You had talked about denials of that motion. And while a motion to confer with a child can be denied, the statute is pretty clear that it's a shall, especially when custody, meaning conservatorship, who is going to designate primary residence, is at issue, or even possession and access. So that's generally how I see that work.
Yeah. So when it comes to the judge actually doing the talking to the child, how much weight does the child's voice or the child's opinion actually, Like, what's your opinion about that?
Okay, well, it really depends on the judge. But what a lot of people need to understand is just because your child has expressed a preference does not mean that your child's expressed preference is what they're going to get, right? Because they're a child. At the end of the day, the judge is going to look at what is in the child's best interest. So if you're talking about how much does it weigh, it really is dependent on the court you're in. I have seen some courts who they say, hey, this child made a preference, and as long as that preference is not completely anti their best interest, I'm going to go with what the child wants. I have some courts who say, hey, yeah, a child made a preference, but that's their child. And so therefore, while they can make that preference and while I shall talk to them, that doesn't necessarily mean that I need to go based solely on their preference. So guys, while I would never, I can't give y'all necessarily advice, you always need to realize and recognize that it's not just enough to say that a child wants to do X, Y, Z, because think about it. If your child had the option, well, not me, I was a nerd, but there are plenty of kids who would never go to school. There are plenty of kids who would eat pizza from sunup to sundown. That doesn't mean that's in that kid's best interest.
Correct. So let's talk about the actual in chambers interview. How does it look like? So what actually happens during the in chamber interview between the judge and the child?
Okay.
And by the way, who's present there? Because sometimes parents think that they're going to be right there in the room.
Well, guess what? You're not. That's number one. You are definitely not going to be present in the room. And one thing that you do need to know is do not, if you have a child, motion for a child interview, do not bring that kid to that motion. The judge will grant it if they're inclined to do so. And then what will happen is they will schedule a time for that child to be brought to them. Generally, if the child is brought to them during mom's period of possession, for example, they will ask that mom drop the child off at the court. Obviously, mom will have to drive with the child, yada, yada. You're waiting in the hallway. But what will happen is the court staff will come out, get that child, and bring that child back to the judge's chambers to do the interview. If a record is requested, meaning if somebody is asking that a court reporter take down what the interview itself and what preference the child has made, there will be a court reporter in the room. If you do not make that request, then no, there's not a court reporter in the room. If you have an amicus attorney on the case, there's a strong likelihood that that amicus attorney will be in the room during the interview. The amicus attorney is appointed to represent the child's best interest, not the child, but the child's best interest. Now, within the best interest prongs, i.e. the Holly factors, you'll see preference of the child in there. But, the child's desires, that's what it's called. But that's generally what it looks like. And sometimes they have an amicus attorney in there because it's a third party that the child already knows and should know prior to doing a child interview. Yeah. And so it makes them a little more relaxed or at ease. But the judge will be in there with the child. And if it's a good judge, it'll be a judge that makes the child comfortable. And that's how the interview will go.
Yeah. Have you seen these done on Zoom as well?
I've never seen, I know that they do them on Zoom, especially because of COVID. I know that they've done them on Zoom. I know that we are able to accommodate them on Zoom. I've never been a part of one that was on the Zoom. When I was an amicus, I was in the room with the judge and the children. Obviously, if it's done via Zoom, any judge that's worth their salt will make sure that nobody is in the room with the child, right? Meaning you guys don't get to stand in the background while little Timmy is getting interviewed in Zoom. They will likely make that child turn that camera around the room to make sure no one's in the room with the child so the child is not influenced.
Yeah. No, I've had that happen before, but that was because it was an out-of-state thing. Child was in one state and the judge was here in Texas.
Well, then that makes sense.
Okay. And so let's talk about how do we balance preferences. When we talk about best interest, somebody has to make the finding of best interest. What is in the child's best interest? This judge who has to make this decision, has to weigh a lot of things. What do you think goes into the judge's thinking?
Well, especially when you're dealing with conservatorship, meaning who's going to designate the primary residence of the child, a court is going to consider, number one, why is the child making that preference? There's a lot of situations where you will see children come in and say, I want to live with my dad, for example. Well, sure, of course the kid wants to live with dad, but why? It's the why. I want to live with mom. Of course you still want to live with mom, or you do want to live with mom. But the question is the why. What is behind it? Is it a simple, hey, I'm getting older, I want to live with mom or I want to live with dad, and they're I'm just at a point where that's where I am in my life. Okay. But if it's I want to live with mom or dad because when I turn 16, they've promised me a Ferrari, we need to know that. And so it's things like that. The other things that the court is going to look at is throughout the course of this child's life, what is the involvement of either parent? Now, if it's low involvement, why is it low involvement? If it's high involvement, great. If you've got two people who are, active with this child, who's supporting that child academically, who's supporting that child's extracurriculars, doing all the things that they're supposed to do as a parent, a court will consider that. A court will also consider, do I have a parent who is asking for a custody flip simply because they don't want to pay child support anymore? Do you have someone who has not been consistent on their child support? And now there's different, keep in mind, child support and possession and access and conservatorship aren't necessarily connected in that it's not just, did you pay your child support? So this is you get to see your child, or did you pay your child support? So it's not in the child's best interest to live with you because you missed a payment. There's all sorts of factors that go around that. If I got laid off, no, I'm not paying my child support, right? But if it's I've always had a problem with paying child support, so I'm waiting till that kid turns 12 so I can run to the judge and go, look, this kid wants to live with me. Because I see that happen a lot too. And it's not always the case, but I do see that happen.
Thank you for bringing that example up, actually, because that's something that does come up quite a bit. Sometimes I'll get a phone call maybe from a dad who's, inquiring about it. And sometimes it's the mom, who might be like, hey, I think this child might be having some thoughts about going over, and that's going to lead to support not being paid anymore. But okay, that's it for now, guys. So this is a short video, but we're going to continue with more topics that are of interest to people who might need a family lawyer, child support lawyer, mediator. Okay, thank you, Dannielle.
Always a pleasure.
All right, guys, until next time, take care. Bye-bye.
Bye.